Hi, my name is Carrie Phaneuf, and I'm the Vice President of Loss Prevention at Texas Lawyers Insurance Exchange. Today we're going to do a Fast 15 on Texas Disciplinary Rule of Professional Conduct 109, since it was amended in October of 2024. So everything here is going to be on the amended version that we got in October of 2024. So first, let's look at Rule 109A. And again, this conflicts rule deals with former client conflicts. So everything I'm going to be talking about in the next 15 minutes or so has to deal with a situation where you have a former client and things that might give rise to a conflict when you have somebody new coming in that may be in conflict with a former client that you represented. So 109A says that when you have a former representation of a client and you have someone new come in and it's the same or substantially related matter, and that person's interests, the new person's interests, are materially adverse to the former client's interest, you cannot take on that new representation unless the former client gives informed consent confirmed in writing. So let me pause here a little bit. 109 has been completely rewritten. So whatever you're looking at prior to October 2024 is not going to apply anymore. If you're looking at ethics opinions or legal authorities, the analysis there is going to be different. Anything that you look at to help you with an analysis of 109, you're going to need to find something that is post-October 2024. I'm filming this here today in February 2026. So just to give you a little context and timeline and help you with any analysis you might have. So 109A is now more in line with the ABA model rules. Although it's not exactly the same, it is pretty much substantially the same. So we have this former client conflict. If it's materially adverse to the interests of a former client and it's the same or substantially related matter, you're not going to be able to take that on unless you get informed consent confirmed in writing. Now, importantly, informed consent is a new term, defined term under the disciplinary rules. So you're going to look in the terminology at the beginning of the rules to find this definition. But what it means is an agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the proposed course of conduct, including the material risks and the reasonably available alternatives. So that's what informed consent means. Confirmed in writing is also a newly defined term, also found in the terminology to the disciplinary rules. And what it says is there's two ways now you can confirm something in writing. It's either a writing that is given by the person, so in this situation it would be by the former client giving their informed consent, or a writing that a lawyer promptly transmits to the person confirming an oral informed consent. So you can have a phone conversation with somebody, we explain the material risks, their available alternatives, all the facts and circumstances about their situation, and they can say, yes, I'm okay with that. And then you would get off the phone and promptly sit down and write an email or letter to them confirming that conversation, that oral conversation, and send it to them. Now, it has to be prompt. You need to do it relatively soon after you have the oral conversation. You can't wait 6 months until things go poorly and then try and confirm it. So going back to 109A, you can't take on this representation against a former client unless you get informed consent in writing. We now know what informed consent and confirmed in writing mean. So let's go through an example real quick of 109A. We have a lawyer who's representing client A in a criminal tax investigation. The authorities conclude that investigation and they decide not to bring charges against client A. Later, however, the authorities begin investigation of client B, who is partners with client A related to the same subject matter. Client B wants the same lawyer to represent him because the lawyer is already familiar with the facts. There is a possibility during the investigation that testimony by client B may implicate client A. For whatever reason, though, client A is open to the lawyer's representation of client B. So what does the lawyer need to do to represent client B in this situation? Well, the lawyer has to disclose in writing to client A adequate information and explanation about the material risks and the reasonably available alternatives to the proposed representation of client B. Then the lawyer has to get an agreement in writing from client A to the representation of client B acknowledging such disclosure, or promptly transmit to client A a writing that confirms his oral informed consent. So that's 109A. Now we're going to move to 109B, and this deals with a situation where you have a former client of a former firm. This part of the rule recognizes that lawyers move around more than they used to. We don't have the situation where lawyers stay at the same firm for 40 or 50 years. And so we're going to try and make it easier for new firms not to be tainted because they've taken on a lateral hire. So what 109B says is that a lawyer cannot knowingly represent a person in the same or substantially related matter as the representation of the client of a former law firm which that lawyer was associated in if the interests of the former law firm client are materially adverse and the lawyer acquired confidential information about that former law firm client that is material to the matter. Now, you could still take on this representation if the former client gives informed consent confirmed in writing. So basically, you have a lawyer at firm A, and he's moving to firm B, and we're trying to decide whether firm B can take on the representation of a client adverse to a former client of firm A. So let's go through an example here of 109B. Lawyer leaves firm A to go to firm B. Firm A represented the wife in a divorce proceeding from the husband. Firm B is subsequently contacted to represent husband in a modification proceeding related to the divorce. The lawyer did not work on wife's case at firm A and obtained no confidential information about the wife. On these facts, lawyer's migration from firm B doesn't conflict firm B from representing husband. So firm B is not going to be prohibited from representing the husband because the lawyer received no confidential information. However, what if the lawyer did receive confidential information about the wife? Then firm B is going to be conflicted unless the lawyer discloses in writing to the wife adequate information, which includes an explanation about the material risks and the reasonably available alternatives to firm B's representation of husband. The lawyer obtains an agreement in writing from the wife to the representation of husband acknowledging such disclosure, or promptly transmits to the wife a writing that confirms her oral informed consent. Now, likely the wife is not going to do this, but that's what she would have to do. The other thing, if we go back to the first part of our example about the fact that the lawyer didn't receive confidential information, I think that's going to be kind of difficult to prove, and the burden's going to be on the lawyer to show that he didn't receive the confidential information. So we'll have to see whether we get some more guidance on that, maybe through an ethics opinion, but that's going to be, I think, hard to prove based on the way that law firms operate today, where everything is done electronically. Usually all the documents are on a document management system that most of the firm has access to. Okay. So the comments to Rule 109 say that when a lawyer has been directly involved in a specific transaction, subsequent representation of other clients with materially adverse interests is clearly prohibited. That said, if the lawyer, while at one firm, acquired no knowledge or information related to a particular client of that firm, and then the lawyer later joined a different firm, neither the lawyer individually nor the second firm is going to be disqualified from representing another client in the same or related matter, even though the interests of the two clients conflict. Now, the provisions of Rule 109 are for the protection of former clients, and they can always be waived by getting informed written consent. Okay, now we're looking at 109C. And this is the rule, part of the rule that talks about whether we can use or reveal information about a former client. So if you have a former client of a lawyer, a former client of a former firm, or a former client of a current firm, if any of those situations apply, 109C tells us you cannot use information to the disadvantage of the former client unless the rules permit or require, or unless that information is generally known, and you cannot reveal information related to the representation except as the rules permit or require. So when you're saying, well, do the rules permit or require, you're going to look at Rule 105, which is our rule about confidentiality of information, and you're going to see whether there are any exceptions there that would allow you to use or reveal information even though it's to the disadvantage of the former client. Or you can use it, the information, if it's generally known. But be very careful here. Generally known does not always mean what you think it means. And you need to look at Texas Ethics Opinion 595 for guidance about what that means. And it says that information is generally known if it is actually known to some members of the general public, not just because it's available to be known if you know where to go look for it. So just because it's a matter of public record does not mean it is generally known. So be really careful there. We're not going to hang our hat on that, and we're not going to hang our hat on whether it's to the disadvantage of the former client, because those are fact issues. And frankly, a former client's always going to think that information that they revealed to you is, and if it's used against them or used later, is going to be to their disadvantage. Okay, so let's look at an example for 109C. About whether you can use or reveal information. So while at Smith & Associates, Andy, attorney, worked on husband's divorce. As part of that representation, he learned about husband's monthly income. Andy leaves Smith & Associates to work at law firm B. Law firm B is retained by the wife to file a modification proceeding against the husband, seeking increased child support based on the belief that husband has more income than he has disclosed. Before taking on the representation, law firm B timely and properly screens Andy from the matter. We're not talking about screening in this Fast 15, but it is something that is available in this situation. Andy nonetheless overhears a paralegal complain that they are having a hard time getting information about husband's monthly income. Question: can Andy reveal what he knows about husband's monthly income? Yes, because firm B has a duty to the wife to tell her the information, and Andy now works at firm B. No, unless it is not to husband's disadvantage. C, yes, because Andy was properly screened. D, no, unless generally known or the rules permit or require. Or E, both B and D are true. And the answer is E. It's both B and D. He cannot reveal information unless it's not to husband's disadvantage or unless it's generally known or the rules permit or require. And I have a little chart up here that can help kind of like sort out when you can use and reveal the information based on what category it falls into. So that's our Fast 15 for Amended Rule 109. I hope you found this helpful. Thanks so much and have a great day.